Well, good morning to all. Let's start this session on the Foreign Subsidies Regulation. I'm Carles Esteban, partner at Latham Watkins, but before I was for many years at the European Commission in different capacities. And I'm very happy to chair this panel on what is probably one of the most important novelties in competition law in Europe of the last few months. As you may know, on the 30th of June, the last day of the French presidency, there was a political agreement between the Council and the Parliament on the new text of the Foreign Subsidies Regulation. A text that is unprecedented, I would say, in many different ways. First of all, it's the first time that a major jurisdiction across the world grants itself autonomous powers to examine the impact of foreign subsidies in companies operating in its own territory. And it makes sense that it's the European Union, the first one to do this, because in Brussels, state aid control has been going on for 60 years, so the Commission can claim that this regulation is an attempt to restore the level playing field and impose a control on foreign subsidies that is equivalent to the control that Europe already has on its own subsidies. The text is unprecedented also for the speed in which it has been adopted. The proposal of the Commission was on the 5th of May of 2021, and barely 1 year and a month later, the political agreement was reached on the text, which shows the strong support that this text received across member states and across political groups in the European Parliament. And finally, it would say it's unprecedented also for the broad range of powers that it grants to the European Commission to scrutinize these foreign subsidies. The Commission will be able not only to examine the impact of any foreign subsidy ex post on competition in the internal market, but it will have also to ex ante mechanisms of control, one for public procurement and one for M&A. We will focus a bit more in our panel on the last one. You've heard in other sessions in this conference how the regulatory environment for M&A is becoming more complex, more sophisticated. You've heard how the Commission is expanding its jurisdiction on the basis of new interpretations of Article 22. You've heard how new rules on FDI are being deployed across Europe. Well, this will be another layer of regulatory control when it will start to apply next year on top of the previous ones. So it's important already that companies start to think how they will adapt their practices, how they will prepare for this new major regulation. And to discuss all this, we have a fantastic panel today with us. First, we will give the floor to Christoph Schroeder. Christoph is the head of the task force in charge of the Foreign Subsidies Regulation. He's been there designing this instrument and driving it through the legislative process in the Council and in the Parliament, and is now preparing its implementation. So we will ask him to tell us as much as he can about the future of this regulation. We have also Sebastian Krujat. Sebastian has been for 6 years the Director of Regulatory for Temasek, one of the major investors into the European Union based in Singapore. So in this capacity, he already had to reflect on how this regulation could impact foreign investors operating on a larger scale in the Union. Sebastian left Temasek a few weeks ago. Now he's acting on his own capacity here, but certainly we will be able to benefit from his wealth of experience of the previous years. And finally, we'll have Elisabetta Righini, a partner of mine and also a former colleague of mine at the European Commission. Elisabetta was for many years at the legal service of the Commission, dealing with WTO and state aid matters, and she spent 5 years at the cabinet of Commissioner Almunia, advising him also on state aid matters. She's one of the top advisors on state aid in Brussels today. So with this great panel, let's start the discussion, and maybe we will start by Christoph. Go ahead.
Yes, thank you very much, Carlos, and thank you for the invitation. Let me know if I'm too far from the micro. Yes, I think I will, in my short introduction, indeed focus on the next steps, but I still would like to pick up, Carlos, where you placed this foreign subsidy instrument. I think it's good to see in how it fits into the landscape of regulatory instruments that exist. And that it really is meant to fill a gap. I mean, on the one side, you have the competition instruments that have been discussed here extensively. You have the mergers, antitrust, and state aid control. And we looked at all these instruments just to discover that there is really no hook to look at possible distortive effects of subsidies granted by non-EU governments. In none of the three existing instruments, it's being done, and there's actually no legal basis to go into detail into these possible distortions. On the other hand, you have the trade instruments, and there, I think it's useful to distinguish the different levels. You have the multilateral framework under the WTO, where actually subsidies are part of the assessment, but very much linked to goods, and in the case of the EU, to distortions that come through the import of subsidized goods. But apart from it, when it comes to services, investment, the international rules don't really apply. There isn't really any useful framework. Secondly, you have free trade agreements between the EU and third countries, which again are very much, to the extent they cover subsidies, they apply to goods, but not services, investment, or acquisitions. And of course, you have the EU subsidy instruments. The EU has a framework, anti-subsidy regulation, but that again reflects mainly the multilateral framework. So we could really identify there is a gap and that the existing instruments don't tackle any effect of foreign subsidies on the internal market, which was the kind of the very first idea to start with this process, and to see whether there is also a legal basis and a justified gap to become active. As there's a lot of attention when it comes to this instrument on acquisitions or concentrations rather, but just to mention, without going into detail here, the instrument applies in principle to all market situations. It's so not only about acquisitions, it can, in that sense, resembles really very much state aid control, which in the EU can in principle tackle all types of subsidies that are given to whichever economic activity that the companies undertake in the EU. Well, I'll already switch over to where we are in the process. Of course, happy to reply to questions that are more on substance. The legislative process is coming to its end on the Foreign Subsidies Regulation. There was a political agreement between the Parliament, the European Parliament, and the Member States and the Council just before the summer on 30th of June. That is the formal adoption of these institutions will take place in November and December. We don't know the exact date yet. There will be very few changes in between, more just linguistic or kind of legal fine-tuning to the extent there are misunderstandings in the text. When the formal adoption is done, there is still, well, a period of about 6 months. There's publication in between, but then 6 months until the regulation actually becomes applicable. That means mid-next year, more or less, that regulation will really start to be applied by the Commission. As Carlos said, it's the EU Commission that is in charge of applying this. For the notifications, which are for very large concentrations and very large public procurement procedures, there's 3 more months delay, so that will be in the autumn of next year, more or less, that companies that carry out these very large transactions are under obligation to notify. And that leads me to another point, because there will be a notification form and a so-called implementing regulation, which will give more details about the procedures on the one hand, but also the notification forms, notably on the information that will need to be submitted when these very large transactions take place. To avoid a misunderstanding, this is not part of the merger notifications under the EU as it exists today. It is designed in a similar way, intentionally, to have synergies where possible in terms of same concepts or same timelines, but it will be a separate process, a separate notification. and also a separate notification form. Well, I think I'll leave it at this, and looking forward to the discussion.
Thanks, Christoph. We'll certainly come back to you with more questions at the end of this panel. So maybe, Sebastian, from the point of view of a foreign investor into the EU, what do you make of this regulation?
Thank you, Carlos. The usual disclaimer first. These are my views, and I'm not speaking on behalf of any company here. But over the last few years, working for a foreign investor, I've had the opportunity to speak to the community, peer firms, their advisors, also the Commission, who engaged with the business community quite a bit, at least with the business community who was aware of the regulation and understood the implications. And so what I'm going to say is informed by that. And I want to focus on three aspects. Number one, the impact in terms of administrative burden on the companies operating in the EU or wish to operate in the EU in the future. Secondly, the impact in terms of on deal certainty, transaction certainty in a wider sense, and capital flows into the EU. And thirdly, I want to try to formulate a few ideas how, when implementing the regulation, the Commission could alleviate possibly some of these concerns the business community and the investor community might have. Maybe starting off with trying to put this in some economic context. There's not reliable data as yet of the subsidies or financial contributions that are being paid worldwide per annum. But just to give an anecdotal example, the US government has provided government support to tackle the COVID crisis, amounting to more than $1 trillion of US dollars, just to essentially address distortion in the US market caused by COVID. That consists of government grants, and it consists of loans by government entities, tax breaks or tax reliefs. And you can now try to extrapolate that to all jurisdictions that are outside the EU, and you can extrapolate that by looking at other policy areas. So you're really talking about a magnificent number and a huge amount of financing that could potentially be in scope of the Foreign Subsidy Regulation. So what I think is the real crux and what needs to be kind of handled is how do you get from this magnificent number of financial contributions on the one hand to a manageable number of cases that the European Commission can actually review and is able to scrutinize, and how can you sharpen the tools to really pick on those financial contributions that are distortive to the EU market. And that brings me to the first point, really on the administrative impact on companies. Because if you look at the Foreign Subsidy Regulation as currently drafted, the companies, the global companies, the large groups, are going to be very much involved in doing this filtering. First of all, they need to record what the financial contributions are that they received. And they will be required to do this on a group basis. And the merger control experts here in this room may know what that means, because the FSR copies the same concept. You go to the ultimate controlling entity, and then you go all the way down to the last subsidiary. There will be groups in this world who have 3,000, 4,000, 5,000 subsidiaries all across the globe, in particular the private equity investors, some of the pension funds, some of the sovereign wealth funds, and large listed groups who are broad and active in many jurisdictions. So that will be a significant exercise. Secondly, financial contribution is very broadly defined. It includes tax breaks, tax reliefs, capital injections by the state. But it goes so far to also look at simple supply relationships. And so if you're contracting with a government entity and you're being paid an amount, or you're being supplied with products or services, you might need to record this. At least this is how it's currently drafted. So I believe we're talking about a significant number, and we are talking about we are operating in an uncertain space. Also because you may not always be able to identify a government as your counterparty. They may operate through entities, private entities, that are somewhat under control of the government. And you need to reflect it all to make it a bit more complicated. You need to quite likely understand this in the jurisdiction where you're operating in. So you're operating in Chile and you're dealing with the Chilean government. You may need to understand whether this entity that you are dealing with is somewhat, or if their actions are imputable to the Chilean government. So I believe that is quite a task and quite a challenge. And then once you have that information and you're deal ready and you want to become deal ready and you have your first filing, what happens then? It's a suspensory regime if you hit the thresholds. The thresholds are very large. It's 500 million EU revenues of a target company. Not many transactions in the EU meet that. That is absolutely true. It's the public procurement contracts that are of large value, 250 million euros. Again, these are very, very large contracts. But if you're in that category of business where you could or may make those transactions, then you have another suspensory filing requirement. And I'm not so worried by incrementally adding another filing as such. I'm more worried about the different policy angles that a company, possibly even a foreign company, needs to handle when making these transactions in the EU. You have now merger controls. You need to understand that quite well, what that means, preventing concentration that are distortive to the market. You're looking at subsidies now with the Foreign Subsidy Regulation. And then if you buy a business of 500 million euros, you quite likely have several FDI filings that are national and with their own national policies and with their own regulators and their own processes. So if you look from 2000s to maybe early 2000s, or I started somewhat doing that in 2009, 2010, and looking where we are now, it is a complete different playing field and a complete different situation than what investors were facing at that time. And that needs to be somewhat handled. Now, do I have any ideas to how to alleviate some of the concerns? It's quite likely, I mean, number one, I would encourage the European Commission to assess the impact of the regulation quite regularly, systematically, and really by not looking just what the Foreign Subsidy Regulation as such does to capital flows, but rather what it does in combination with the other regimes. Does it prevent in any way capital flows into Europe? Are companies saying, this is just a step too hard, it's too costly, and it's too uncertain, and I'd rather deploy my capital somewhere else? I think that is very, very important to find out. Secondly, I think one wants to assess whether, after a few years, whether it makes sense and it's efficient to put 99% possibly of the companies go through a mandatory regime and filtering system where at the end of the day you might say most of what I've seen is actually fine and is possibly these were financial contributions that were paid to fix a problem in the jurisdiction there where the companies are from or in other markets, and then you may have a percentage point of problems that you really see, for instance, a subsidy that is particularly paid to give a local company a head start in the EU. And whether these actors who do this actually operate that transparently with the Commission and go through this process, or whether they're using clandestine structures to somewhat circumvent the system. And in that regard, whether maybe an ex officio tool or using that more often as opposed to be very, very very focused and very heavy on the M&A tool is possibly the better way forward. And thirdly, and I think that has been raised by other associations before, is the recognition that the European Commission should give to the interests of non-EU countries providing financial contributions. There may be perfectly fine reasons for giving financial contributions or subsidies even to companies to, again, fix an issue in that market. And what the regulation does, or at least as I read it at the moment, is when it comes to a balancing between the distortive effect and any non-competition related effects that the foreign subsidy might have, due account is principally taken or in relation to EU concerns and not so much foreign concerns. but subsidies are paid, usually pursue national interests abroad, and they are by nature non-EU interests. So maybe to wrap up, I wanted to highlight the administrative burden that lies ahead for large groups of companies, and I agree with Carlos, quite likely it would need to start now, getting prepared. Secondly, I wanted to encourage the European Commission to really systematically assess the impact, to ensure that financing doesn't get discouraged and that capital flows are sufficiently coming into the European Union and don't go anywhere else. Thank you.
Thank you very much, Sebastian. Let's move now to Beta, how you see that from the point of view of an advisor, and what are you already doing with companies to try to anticipate the impact of this regulation in a few months?
How many hours do I have? Because we could spend the entire day here debating this. Yeah, I'm trying to. It is. Can you hear me? Can you hear me? Okay, this works then. It was the mic. Okay, so we have been discussing this FSR quite at length in the world since the Commission had the first idea to propose it, and Christophe has been very minimalistic in its presentation today, but he said rightly he's speaking about it a few times every week by now, because it is a big piece of news. So if you allow me, Carlos, before I move on to tell you what we do in terms of compliance for our clients, I would like to take a step back as not only a practitioner, but also an academic person who has been dealing with trade and subsidies in various forms for all of my careers now. And I won't say when I started, because it would, it's a very long time ago, let's put it this way. So from an academic point of view, this is indeed a huge change in tack on the part of the European Union, which traditionally, for its own very history, has always been at the heart of multilateralism. We have, in fact, moved from the GATT and WTO perspective, then at the beginning of the 2000s with a new trade policy after the failure of the Doha round, which was focused on regional agreements and bilateral trade agreements, to now the FSR, the Foreign Subsidies Regulation. So it is, in everybody's eyes, a bit a declaration from the European Commission that working with others has failed. And working with others over the past 2 decades had meant also trying to push what we call the WTO plus, or sort of state aid rules in the regional and bilateral trade agreements. So this is a big piece of news in itself. Now, had these, Christophe at the beginning was saying we have identified a gap. I mean, member states had called for an instrument like this forever, right? When working at the European Commission and dealing with policy, you would encounter a request of this kind at least at every new college, at the start of every new college from the member states, usually France and Germany. Again, very personal point of view, what had happened that has made it possible? Maybe the UK has left and therefore a liberal voice has gone. Maybe, as I said, the previous international trade agreements negotiated weren't working as we hoped. Maybe the world is going towards an entrenched nationalism. Well, that seems unfortunately quite evident, and this is what where we are now. But what is worrying is also that the European Union as such, between state aid and also its own EU funds, is actually one of the largest provider of state support. It is transparent, we grant you that, unlike in other jurisdictions, but still it has also very strong, let's say, defensive interests. So how this instrument will then play in the bigger scheme of things when other countries, third countries, will realize what it means for its own companies. And I'm not necessarily thinking about China, or I'm also thinking about the US and the UK. So with my academic hat, very worried about the meaning and the impact of this instrument. Switching to my practitioner hat, very worried about what Sebastian was saying. So clearly we see the effect on the clients already, not only because we are preparing compliance, about which I will speak in a minute, but because it really becomes yet another burden in coming to Europe to invest or to do business. It's yet another consideration to keep in mind on whether you really want to go through the motions of abiding by also the FSR in order to do business in Europe. And this is worrying, again, at a macro level. Why you would say, okay, if the deals are so big and the public procurement contracts are so important, are these companies that will be affected, don't they have the resources? Can they pay Latham Watkins or whomever else to do this? Why should they even think about not coming to Europe anymore? Well, one of the problems we are encountering is actually what Sebastian was describing. I mean, the notion of financial contribution in the Foreign Subsidies Regulation is so broad that if you sum up selling pens, I have a client who's selling pens to governments around the world, and anything else they are doing, just by the fact that you are selling goods to a public entity, you need to record these. And sometimes it is absolutely not possible to trace it back. It's just, you know, they don't have a record that is easily collectible and brought into, I don't know, an Excel sheet or in usable form. This data doesn't exist. So how we are trying to assist our clients is actually, first of all, to start thinking on how to comply for the future. So from now on, setting up internal reporting mechanisms that will help groups tracing all of their interactions with the public entities. And for the past, I mean, do as much as it's possible to trace at least the major interactions that could fall under this very broad concept of financial contribution. Now, we are all looking forward to seeing the implementing regulation, Christophe, and you haven't told us when you're going to publish it, because for comments, we will have a lot of comments. Because in fact, I mean, this concept of financial contribution is a very tricky one, in the sense that whenever it is said, well, this is the external aspect of state control, I mean, not true. And no company in Europe or no company that receives funds from European governments is required to pay attention to any interaction with the public entities. It's only required to pay attention to when it receives an aid, which is a financial contribution that is selective, that distorts the internal market, and that gives it an advantage. So it's the bar is a lot lower than in the Foreign Subsidies Regulation. Also, normally in Europe, the burden is on the member states. So it is the public authorities that have to worry about notifying the measures of support they grant to the economy. It's not the company itself, which leads to a number of frustrations very often on the side of the companies to be a bit at the side of this procedure, but certainly it doesn't impinge as heavily on their business. Another aspect which is therefore worrying is, and I mean, with the experience we have of state aid control, one thing we know is that very often, even if the responsibility is on the member states, it is very hard to get the member states to actually notify the aid. I mean, a concept that didn't even exist, the one of illegal aid in the original treaty, right? Our founding fathers, mothers weren't in the picture at the time, but so our founding fathers thought that every aid will be notified. It's only through practice that it was realized by the Commission and by the court that there were a number of gray areas that could qualify as an aid and that were not notified, and so that the Commission was granted the powers to actually go after this illegal aid. Now, the Commission adopted a communication on the notion of what an aid is in 2015. I worked on that for 5 years when I was the legal advisor to Vice President Almunia, and I was still not able to have it approved under my clock. It shifted a year later, and it still is not clear what an aid is. So how are we going to, or Christoph, how are you going to, how are you going to actually police this instrument worldwide? What kind of powers or superpowers will the Commission have to actually know whether a company has declared everything, whether there isn't more, whether, and yes, there are hefty fines if you don't do that, but I mean, it is so, from what I'm experiencing already now with my clients, it's already so difficult when you are inside a company to find out all the relevant information. How are you guys going to make this effective? So will this become a bit of a patchwork? And frankly, my fear is that a regulation that then doesn't work or legislation that then doesn't work then produces a worse effect than if it wasn't there, because it comes to get ignored. And if something is too difficult to abide by, then I guess companies will just either go elsewhere, as Sebastian was saying, or ignore it with a very sort of discredit for the EU legal system certainty. I will close here.
Thank you very much, Beta, also for providing a bit of context into this debate. So I think we need to go back to Christoph before opening the debate to the floor. And Christoph, I think there are three broad themes that have emerged from this discussion that I think it would be great to hear your views on. First are maybe the systemic issues that Beta referred to. No? Is this a protectionist tool? And how the Commission will avoid that it ends up being used as a protectionist tool. And in relation to this, what is the reaction of third countries? Are already third countries approaching the Commission, expressing concerns that the Commission will second-guess their power of granting subsidies under their own jurisdictions? No? Is there a risk of retaliation? I think this first theme about the global implications of this regulation is very interesting. Second, I think it's all the debate about administrative burdens, as both Sebastian and Beta have explained well. The broad notion of financial contribution of this regulation means for many groups that the criteria of reaching 50 million of financial contributions will be not discriminatory. All of them will reach these 50 millions very easily. Imagine companies, I don't know, pharma companies that sell to governments, utilities that sell to governments. The only criteria that will matter for them is the turnover, the 500 million turnover of the target established in the EU. If they buy someone with more than 500, they will have to notify in any case. So this involves a serious administrative burden in trying to gather all these data, as both Sebastian and Beta said. What the Commission can do here? We know you are preparing an implementing regulation. Is this a problem that you have spotted, and how you plan to deal with it? And finally, the last issue that Beta mentioned. I mean, there will be a large administrative burden to many companies, but only few of them will really present a real problem. No? So for the problematic cases, for the few ones where you will really want to investigate the impact of the subsidy in the EU, are your powers sufficient? Will you be able to dig into what financial contributions some complex economies have granted to their companies that are operating in Europe? How the regulation gives you the tools to deal with that. If you could answer at least some of these issues, that would be great, and then we'll open the discussion with the floor.
I will even try to answer all of them. Okay, thank you, Beta. I start with the easy one, Beta, because indeed, I forgot to mention when the implementing regulation and the notification form will be published for consultation, that should be in December. And I'm sure, yeah, we actually should get a lot of feedback from stakeholders to, well, which are concerned, and in many ways, as here Sebastian and Beta have pointed out, I think we have realized there is, or we know there's a need, at least to fine-tune many things with these documents. Well, let me start. Well, Carlos, I follow your questions. Is it a protectionist tool? I think Beta said it, this demand of having a control of foreign subsidies has been recurring for many, many years. And there's a reason for this, because in the EU, state aid is controlled. So the subsidies that member states give to companies in the EU is controlled, follows very sophisticated rules. But there's nothing like this for subsidies given by non-EU governments which impact the EU. So we think it's a fair concern, and it's really the idea to create a level playing field between companies that get EU money and non-EU money to make sure that these non-EU subsidies don't give these companies, the recipients, an advantage vis-a-vis others. And there have been many companies also coming to see us and have complained about that, you know, their competitors get money from outside the EU and there's nothing to be done so far. So I think that's really the intention, a level playing field, and not the intention to make the EU more protectionist. Still, and it says also in the political agreement reached in June, preferable would be a multilateral solution under the WTO, and that is reaffirmed by all EU institutions in this political agreement. That would be the preferable solution, not a unilateral solution now as proposed by the EU, but at the moment the prospect of having an agreement under the WTO to control subsidies more broadly than today is not realistic, and the trade colleagues tell us it's not realistic in the coming years. The reaction of third countries. Actually, there haven't been many reactions. There are some countries investing in Europe, I think it's Canada, I can mention Singapore, who have approached us, and I think generally both companies and governments are in two minds about this, because they see the usefulness of this instrument, but they also, well, they would like to have the benefit of it, but not the burden of it, let's say. So I think that's why we haven't really had any reaction completely negative about this, because they see the idea and the justification that there is actually subsidy control within the EU, and that gives a legitimate reason also to do something about potential distortions from foreign subsidies. The risk of retaliation, well, we don't know. I think seeing the reaction so far from third countries, I'm slightly optimistic that there will not be a big pushback, but I think it will depend on how the instrument is applied and when specific cases come up that may be controversial. That we don't know yet today how then third countries or companies will react. So I think that we could only speculate. Then, yeah, the chunk of the comments on admin burden. I think I should say these two concepts which are relevant and at the core of this debate are, on the one hand, undertaking, on the other hand, financial contribution. These were not invented here for the Foreign Subsidies Regulation. Undertaking is a concept, well, as you will know, that's been around in competition policy for many years. We use that concept. Financial contribution is a concept under the trade rules. So again, it's a concept that we used and copied into the Foreign Subsidy Regulation. So the purpose was not to make it particularly difficult. It's true, it casts a very wide net. And we know this. But I think intentionally, at least now in the basic regulation, it's there to capture all possible situations and possible circumventions. So I think there's indeed a justification to have it in the basic regulation. Second question is how we will apply it. And there we still have some margin, and the notification form implementing regulation give us some margin then to already try to identify more what are the relevant elements. And we're having internal discussions on how to make it sure that there's not an excessive burden, how to narrow it down, at least in the practical work. Yeah, so, and that's something we expect also from the public consultation on the notification form, ideas on how to focus on the most relevant situations and to capture this. But as this is really a completely new instrument that doesn't exist like this anywhere else in the world, it's difficult to narrow it down from the beginning because it opens up a huge possibility to circumvent it. Yeah, on the info gathering, maybe just last comment, I think the regulation contains a number of really strong instruments to get the information. That in practice will be the difficult bit to how to get the information from the companies and the third countries. I think there we can learn a lot from how the trade defense instruments in the EU are applied, which are from that point of view in a very similar situation to get information on subsidies in third countries. The regulation envisages not only formal request for information, it also even envisages inspections at the premises of the companies, either within or outside the EU. It envisages fines and periodic penalty payments if the companies don't cooperate. And we do think the companies have an interest to cooperate because, after all, they want to do business, and they are often already doing a very big business in the EU. So I think we have, well, we can count on some cooperation of the companies, but there are also a number of tools, if that doesn't work, to get the information if necessary.
Thank you very much. We are approaching the end of this panel, but I think it would be good to have an opportunity for questions from the audience. Let's start here.
For inspection of companies. Have you, this regulation is aimed at China. I mean, behind the scenes, China is clearly looming as one of the major economies in sight. I mean, have you spoken to the Chinese authorities about how you're going to inspect entities in mainland China and gauge how their subsidy structures are working, or the sort of channels of funding between a Chinese SOE and the shipping companies in China?
Well, first I would say I don't really agree that China is the one and only target. When you look at the foreign direct investment in the EU, actually the investment from China is still very limited. And distortions and subsidies can come from many other countries. So we really wouldn't want to single out China. And it also will depend very much on the sector. Now, if you look at the energy sector, for example, China is not not very active in Chinese companies, or indirectly the Chinese state is not very active in Europe. So it will really depend on the situation. And we haven't really discussed or negotiated this kind of arrangement or provision with third countries. I think we, in this area of inspections, we can learn a lot from the existing competition instruments as it comes, of course, to antitrust instruments within the EU. When it comes to inspections outside the EU, under the anti-dumping and anti-subsidy regulation, there's experience with how this is done with third countries. So I think we have relied mainly on these precedents.
Other questions?
Can I add something?
Of course.
Or add in part to the question. So the one thing that I would like to say with regard to this last remark, what we are seeing now is that the companies that are most worried about this are not Chinese. They are European. So, I mean, we talk about a protectionist approach which is hitting us is shooting us in the feet, because our most successful companies are active worldwide, have this issue. Financial contribution talking, then we will see if these are subsidies, but they do, procure trains everywhere, or sell energy everywhere, or all sorts of industries. So, second thing, to follow up on this question, how many people will you have to do this? Because at least what I hear in the Brussels quarters is that budgets get tighter, resources get diminished, and this is a whole new area. DG Comp used to have 1,000 people under our clock. I think, Carlos, you might have more updated figures, or you, Christoph, and they weren't enough to manage the 3 instruments that existed. Now there is the DMA coming up, then the FSR, so I'm wondering how many people you have. And just one little comment back, Christoph, on the level playing field. Again, as an academic in this area, if you study the compatibility rules for state aid since the beginning of state aid control, it is a myth that Europe controls subsidies. Europe controls subsidies in the sense that it steers them, but it doesn't mean that we don't grant them. We are among the largest public financiers in the world, but we steer them towards our own objectives, right? So if you map the compatibility rules, they give you the history of European social economic development throughout the years, starting first with the big heavy industries in the 70s, then moving on to the restructuring, the environment, the financial crisis, now COVID, and so on. What we are saying here is that we are going to do the same control on how other governments spend their money for their industries. And what to me is very odd is I wouldn't want these other governments to do the same on the European economy, because our values are not the same as other countries' values. So, this to me, it doesn't really strike as a level playing field, and it's very different from the kind of subsidies control that it's linked to trade, so to goods or services. Services are not covered by the WTO as far as subsidies are concerned, but it would be the same thing. It's one thing to say, okay, you are coming in here, there is a markup that I need to calculate for the price of your incoming goods and services. And another thing is to say, I'm going to check when you're coming here to invest if the money you have received are aligned to my objective, because the balancing in the FSR is linked to the European policies considerations. So, again, good luck with that.
So let me check first if there is still a question. Alberto.
Just one question. What is the relation between the European foreign subsidy regulation and the national foreign subsidy regulation that in a number of countries we already have. Because that's, I mean, the issue, the general issue Elisabetta raised, that is, are we going to be more and more protectionist and to affect, in fact, the investment process in Europe? We have layers of controls.
Thank you. If there are no more questions, then we will allow Christoph to end this with 3 topics still left on the table. Resources, who's going to do this? Second, the balancing test. How are you going to apply this tool that we've not discussed at all, but the regulation still allows the Commission, once it has identified that a subsidy will have a negative impact on competition, to balance it with the positive impact of this subsidy. How are you going to do this balancing test in view of what Beta mentioned? And finally, the relationship with the national authorities and national systems.
Yeah. I start with the last question. I mean, the Foreign Subsidies Regulation is not really applied by the national authorities. They have a role in the decision-making process, and they can also support information exchange. So I think there will be a cooperation with the member states. But you may also have in mind the FDI screening regulation, which is done actually exclusively or almost exclusively at national level. And there, indeed, the regulation has included kind of information exchange, that these national cases, which may not be in the public domain actually often, but maybe about the same transactions as under the Foreign Subsidies Regulation, that then there is an information exchange and coordination between the Commission and the corresponding national authorities. How this works in practice, yeah, we will have to see, but at least there is an awareness that there needs to be a coordination about these cases. On the resources, there will never be enough, of course. And yeah, it's not clear yet how many resources there will be, and of course the resources will determine what can be done under the regulation. Again, I think there's an awareness about this, but well, resources, as Beta will know, is one of the most difficult issues, well, probably everywhere, but in particular in the Commission. Let's see, it's not yet determined exactly how many people will work on this in the coming months and years. On the state aid, well, I think we should avoid getting now into a general discussion of if state aid policy in the EU is effective or not. I think I have a less pessimistic view, and I think there is a control, if only. But I think there's more about proportionality. Very often state aid policy sets exact, even percentages, how much a subsidy can make up of a certain investment or production cost. So I think it's fair to say that the state aid policy has an effect also already on policymakers, I think, when they decide subsidy programs. So there's a kind of this preemptive effect, which is difficult to measure, but I would say there is. The only thing I want to add is, of course, we cannot be stricter vis-à-vis foreign subsidies than under our own state aid rules. And I think that the state aid policy will be the benchmark. And I think we also like to tell member states the more lenient they want the Commission to be on state aid control, that will imply we will have to be more lenient on foreign subsidies as well. There, of course, we will have to see in detail how this plays out in particular areas and cases, but certainly that would be discriminatory to be stricter on foreign subsidies. So I think it could also be an incentive in the area of state aid policy to be stricter where that is useful and may not have been the case over the past years.
Perfect. Thank you very much. I think with this we can end this this session. You see, this is an area to watch, to keep in your minds in the coming months. Maybe the next step is the formal adoption of the regulation, followed by the publication of this implementing regulation, where we will know much more what this means in practice in terms of what information the companies will have to bring forward. In December, Christoph has told us. And then the entry into force, probably beginning of the next year. and the entry into force of the notification obligations in the autumn of next year. So those are the next landmarks that you should not forget. Thank you very much for your attention, and thank you very much to the great panelists.
This is a critical bet. I wasn't prepared.
You have completely dodged my...